us throughout the organizing this webinar. I heartily welcome our Administrative Officer, Professor Gadekar sir. I also welcome all HODs, all teachers, students, and all the other participants who have joined for us today for this webinar of IPR awareness program. Our nation is admiring the 75th anniversary of India's independence under the banner of Azadi Ka Amrit Mahotsav, and Government of India has taken initiative of National Intellectual Property Awareness Mission, under which awareness and training would be imparted 1 million students on intellectual property rights. As part of this mission, our college is organizing this webinar. I would like to introduce today's speakers, Pratik Hendre sir and Anshul Verma sir. Pratik Hendre sir completed Bachelor's of Biomedical Engineering degree from Vidyalanka Institute of Technology. Sir has also completed their post-graduation diploma in Management Marketing from Bellunkar Institute of Management, and also completed LLB degree from Mumbai University. Anshul Verma sir also has completed BTech and MTech Mechanical Engineering from IIT Banaras Hindu University. Both are working as Group A Gazetted Class 1 Officer under Ministry of Commerce and Industry at Indian Patent Officer. Both has been working as examiner of patents and design since last 4 to 5 years. Pratik sir has been appointed at this post after achieving third rank at the Indian national level exam equivalent to UPSC exam. I welcome you, sir. I hope everyone will be benefited from this webinar. I would request Mr. Pratik sir to continue with this session.
Ma'am, can you hear me?
Yes, sir.
Okay, thank you so much. Thank you so much for the introduction, ma'am. And I welcome you all. I think there is some error from Pratik sir's side because he was trying to share presentation. Okay, never mind. I hope I can share my screen. Just a moment, ma'am. All right.
Okay.
Just there's some, I think, technical problem in here. Just give me 2-3 minutes, okay?
Okay, sir.
Maybe. Okay, so let me just begin with. So this presentation, everybody can see, right?
Yes, sir.
Okay, wonderful. Well, thank you so much, ma'am, for your introduction. My name is Anshul Verma, and on today we shall be discussing about the intellectual property rights. Okay, so this is the mission under the Government of India, which is named as NIPAM, that is National Intellectual Property Awareness Mission. We all know that we are completing 75 years of Azadi Ka Amrit Mahotsav. So on that very occasion, the Government of India has come up with this national mission to aware the students of India about the intellectual property rights. I shall be explaining you what is the importance of intellectual property rights as well as what makes an intellectual property rights. So if you can see this very logo, that is IP. Okay, IP stands for intellectual property, right? Property is something of which we are an owner of. Okay, we are the proprietor of. So that is our property. It could be your home, it could be your car or pen or pencil, anything. But intellectual property is something that comes from your mind, from your intellect. So if you can see this logo, in this circle, there is a figure. This figure basically represents a brain along with neurons. Okay. So anything that comes from your brain becomes your intellectual property. Okay. Right. So when I talk of intellectual property, so it is like you create something new. Okay. Majority of the people do have this, scenario in their mind that they have to invent something. They have to come up with some great ideas. Only then it can be your intellectual property. So for the reference of those people, I have put in this PPT, this very slide in which you can see a paper clip. This paper clip was registered under patents, okay, in 1919. So it is the year when we were fighting against Britishers and that Jallianwala Bagh in massacre took place. So at those in those days, if you would have asked an Indian that do you know intellectual property, they might not be having even a slightest of the idea. But people around the globe, to be precise, in the Western world, they were coming up with different innovations, as simple as a paperclip. And everybody, in fact, a 6 or 7 year old child must have also used a paperclip. So invention, or if I say intellect which gives you a solution to a problem, the solution can be as simple as a paperclip. It always need not to be a very high-tech gadget like we usually see. Now, this is the Global Innovation Index, which is presented by WIPO, World Intellectual Property Organization. Okay, as per WIPO, India in 2020 was at 48th position around the globe in terms of innovation. Okay, and I think in the rank improved to 46, which I have not mentioned over here, but there is a jump of 2 ranks. So if I talk of India, which is having a huge potential of young people having innovative and creative mind, this number 48 just does not justifies its position, because we are the second most populous country in the world and about to overtake China in that. So with such a big country that is seventh largest, with second largest population, with a pool of young talented people, 48 number is not at all justifiable. So that is why government has come up with this idea of intellectual property awareness, so as to acknowledge people, to impart knowledge to the young minds, that how we can make our India improve in intellectual property in terms of innovation. So if I talk of intellectual property, there are few things, namely patents, designs, trademarks, geographical indications, and copyright. Okay, we'll discuss all of these one by one. Just to mention how different intellectual properties are embedded in a single product, I have kept over here this MacBook. You can see the design. Okay, design, like I have mentioned earlier, it is one of the intellectual property, right? So you can see the logo, this Apple logo over there. So this Apple logo represents a trademark. Okay, the LED screen of this very laptop or any mobile or any TV, that comes under patents, and the copy that nobody actually reads, that is a user manual that comes with every electronic item, that comes under copyright. So this is just a brief introduction of different intellectual properties that you can see in a single product. Okay. I have said earlier, I can hear some noises. Somebody wants to say something? Ma'am, I'm audible now?
Yes, sir. You are audible.
Okay.
Yes, sir.
Like I said earlier, anything that comes from your brain, from your mind, becomes your intellectual property. So what you have to do is you have to apply your brain with the given resources and obviously some input, some labor, to come out with a property which becomes your intellectual property. And that property has to be something that would eventually ease out the working of anything, ease out any question, any problem. Okay. So what is the importance of intellectual property? So as students, basically what we do is, if teacher gives an assignment, only 2-3 people actually do that, and majority of the class just copy it. So the person who has actually done that has this thing in mind that I have done all this work and everybody is copying that, right? So you do get an exclusive right. Okay. So please mute your mic. Yeah, thank you so much. So what I was telling is it gives you an exclusive right for the invention that you have done. It can be with regard to patents. It can be with regard to design, trademark, copyright, anything. Okay. So you will get an exclusive right. Your work will be protected. Nobody can copy it and you can use it for monetary benefits. Okay. So that is the commercialization of what you have created. These days, you must have seen so many IPOs, so many startups that are coming. In fact, this Shark Tank, this program is also there. So people are coming up with innovative ideas, and big people, rich people are investing in those ideas. Everything around you is related to intellectual property. For example, you can use your intellectual property for your own use. You can license it or assign it to someone else. You can ask someone to open a franchisee, or you yourself can open franchisee of intellectual property that is assigned to someone else, or merchandise. For example, McDonald's, you have seen. So it is not that the CEO of McDonald's will be coming to each and every outlet. They just, people open their franchisees. So that is how you can commercialize your intellectual property. You can commercialize your product. What is the difference between a common person and a businessman? Like when I was doing my master's, I published 2 research papers in international journals. So these two things were definitely were with me. That is the pride that yes, I have 2 research papers published in a very good journal. And second is academically, it boosted my marks. Okay. But apart from these things, from the business point of view, if you look at what you could have done is you could commercialize it, you could give it a brand value, and you could have earned over that. So that is the difference between a common person who thinks about intellectual property and how what a businessman thinks about intellectual property. And that is why whenever you see any product in the market, there is a name associated with it, be it the Apple logo, be it the Samsung written over it. So that value, okay, which is associated with intellectual property, comes only because this intellectual property gives you a guarantee. Okay, this gives you a protection right that you are the only authorized user of it. You can only use it for commercial benefits. So that is how intellectual property is really important. So like I have mentioned so many intellectual properties. First of all, I'll begin with patents. So patents is basically an exclusive right. Okay, patent is an exclusive right which is given to an invention, and in that invention you have to register it with our office. In that you have to specify all the whatever the invention that you have come up with, so that a person who is average skilled in the art can also reproduce the same invention. Okay, so you are getting an exclusive right for your work, for the invention that you have done, and that exclusive right will be in a sovereign state. In this case, it will be in India only. It is not that if you file a patent in India, it will be like eligible for USA or any other country. It will be eligible only in India. Okay, so for inventions you get a patent, right? And it is for a limited period of time, that is 20 years. If you invented something, you will be granted a patent for that, that you have the exclusive right for that, and those rights are provided to you for a period of 20 years. And this right, like I said, for 20 years is because technology is changing day by day. Nobody uses Nokia 3310. That is what we call it. Nobody uses it nowadays. That was a keypad technology. Now it has changed. It is open to all. Now is the time of touch screen. In fact, foldable screen. Okay. So patents, like I have told you, exclusive right in a sovereign state. Okay. And obviously, when you get a patent, you can exclude others from copying it. Okay. So for patents, if I talk of India, the first patent was basically granted in 1856. Now look at the year 1856. Mangal Pandey mutiny took place in 1857. So you can see India is not at all able to, grasp what is intellectual property, because in those days, like 200 years ago, almost 200 years ago, people were filing for patents, and we Indians had no idea what patents are. And that is why India as a market is a consumer market. Okay, it is not a developing nation it is not a developed nation. We are still developing and we are a consumer market. And one of the reason for that is the lack of awareness of intellectual property right. So this person, like I said, in 1856, Alfred D. Penning filed for an exclusive patent in Kolkata office under the name of an efficient pankha pulling machine. So this is nothing, just a hand pulled machine in which you use your hand to rotate a fan. So you can see how how old this IPR is. And even in 2020, we are providing the intellectual property awareness mission just to aware the people of India that you have the potential and you can come out with different inventions, so that India, instead of being a consumer, can become a provider. Okay. So these are some of the inventions that you also must be knowing, like phonograph, telephone, the famous Wright brothers came up with aeroplane, rabies vaccination, and penicillin, right? But if we talk of India, India has also come up with the various inventions like nano car, which comes in a budget value of a bike, right? Then hepatitis vaccine and the famous Jaipuri foot. Now see, the invention need not to be like a very, like I said earlier, paper clip is an invention. So like Jaipuri foot, and very affordable prosthetic that can be used by people who are not that much prosperous. So these are also inventions in which it is not always to be like very hi-fi technology. A very simple thing that is affordable to people also is an invention. So look, like I was talking about patents, the very simple you can see over here is in India, what we do is we used to keep our hand over there, like if it's raining. So a person came up with an invention of making a simple cap so as to protect a baby while, showering. So you can see the invention, a simple invention granted a patent. Now this one, to be honest, is a technically advanced invention which requires skills and resources like this band, and the whole of the mobile can be projected on your wrist, right? And the drones that we see nowadays, this is also a technically advanced invention, and the swiping machine that can be used in phone. So you can see the patents are like, inventions can be as simple as this cap. Anything that makes your work easier can be registered under patents. And a drone, high-tech technology, is also there under patents. So I'll be discussing with you how to file a patent. What's the patent application filing procedure? So first of all, there are few forms that we have to submit if in case like you come up with an invention. So you have to fill in few forms along with your invention. The first is form 1. In the form 1, you have to submit your details, like who is the applicant, who is the inventor, the address, and what is the title of the invention. So when I say patents, there are two things: applicant and inventor. For example, if you are a person working in, let's say, Samsung company, and you invented foldable touchscreen, that what we see in market these days. So you are the person who invented that very foldable screen. So you will be called as an inventor. Okay. But when you file for a patent, because you are working under Samsung company, Samsung will be called as an applicant. So in form 1, the details of the applicant, that is the company, the details of the inventor, that is the person who actually invented those things. Okay, so all these details has to be submitted in form 1. Then comes form 2. It's basically the form in which you have to submit all your work. Like it's written over here, your work including title, background of the invention, particulars of drawing, if there are any, brief description of drawing, then description of the invention, claims, abstract drawing. So it is like a thesis, a paperwork that we have to submit, after completion of our graduation or post-graduation program. So like that only you have to submit it along with form 2. Then comes form 3. Form 3 is basically for those people or those companies who have already filed their patent somewhere else, okay, apart from India. So that is just to have our idea, this just to have our office this knowledge that a person is filing for a patent in India, and as well as he has also applied for the patent in other countries as well. Then comes form 5, which is for the declaration of inventorship. Like I said earlier, applicant, for example, let it be Samsung, inventor is any person. So in form 5, the applicant has to declare that this is the person who has invented the thing, right? And then comes form 18. After submitting form 1, 2, 3, and 5, it is not that your application will be processed right away. First of all, it will be published. After the publication, it will be processed by our office, and the processing is done only after you submit Form 18. Form 18 is basically the form for request of examination. What many times happens is, like in our country, people come up with small inventions, so they do have this uncertainty in their mind whether their invention is up to the mark, whether their invention is new. Like for example, if you filed for a patent today, and after 3 4 days you got to know that somebody else has already filed for this very particular patent, okay, for the same invention, a patent has already been granted. So in that case you can withdraw. So we have this Form 18, that after you have this full confidence that nobody else has yet submitted an invention like yours, then you can go for examination. Then you file Form 18 that yes, I want you to examine my application, and after filing Form 18 only we will be examining, okay. And when you file Form 1, after filing Form 1 you will be given a time period of 48 months within which you have to submit Form 18, okay. So after Form 18 only your examination will be examined. Now if I talk about the fees, like this was a major concern earlier, like the fees for filing patent is so high. So government has basically reduced fees by 80%. You can see over here, other than natural, like other than an individual or a small company or a startup, okay. Big companies have to pay an amount of 8,000 with along with Form 1, okay. And for Form 18, that is the request for examination that I have just told you. With that form, they have to submit 20,000 rupees. After that only their application will be examined. Now, for a natural person, like for an individual who is working alone, standalone individual, or for a startup, like these days, government has come up with Startup India, Stand Up India, Make in India. Okay. So for all those people who are registered under these schemes, as well as educational institution, for them, fees is only 1,600 for Form 1 and Form 18 is 4,000. So you can see the difference in the fees, 28,000 versus 5,600. Okay, so that is why it is said that patent filing has become so cheap that everybody can file for a patent if you think that you have something which can be beneficial for the public. So go and file for a patent. Okay, so filing procedure, like I have said earlier, different forms you have to submit. Earlier, it was only the hard copies that people have to submit in our office. And there are only 4 offices in India, that is in 4 metropolitan cities, namely Delhi, Mumbai, Kolkata, and Chennai. Now there has been a provision of online filing, that being at home only, you can submit all the forms online, right? And this is how that website looks like, in which you have to sign up, and after sign up you have to submit various forms, that you need not to come to any office for filing of your patents, right? It is also said that patent filing takes a lot of time. So government has also come up with something called expedited examination. Expedited examination is like you will be given a patent. The patent can be granted within 6 months or maximum 1 year. Within 1 year time, you will be getting a patent for that. Okay, the time has been reduced. Earlier, it could be like 2 years, 3 years, 4 years. But with expedited examination, the time has reduced. And expedited examination is for startups, small entities, if the applicant is a female, and for government institutions as well as educational institutions, or if there is some treaty between the Indian patent office or patent office of any other country. So you can see the expedited examination. These all things are linked with the various policies, missions of government of India, like Stand Up India, Startup India. Okay, so things are basically getting easier to file patents. So like I said earlier, India was 48th in position. To improve that ranking, that India, instead of becoming a consumer, becomes a creator of inventions. So all these provisions has been done. So let me just discuss with you the patent application process. Okay. So like I have said, Form 1, Form 2, Form 3, and Form 5. What generally happens is, if you are like 80% or 60% done with your invention, like today you are like 80% I have done my work, but still 20% work of the work is remaining, you can go and file your patent with that 60 and 80% of the work. Okay, that will be called as provisional specification. And our office will give you a time of 1 year. Within 1 year, you have to submit your complete work. That will be called complete specification. Okay, it is not like you have to wait till the completion of your of your work. even with 60-70% of your work, you can file for a patent and you can fix a date, because patents is only about priority. Who is having the priority? Two people working on the same invention, but the one who has filed for a patent before the other one will be granted the patent, and other one will not be granted the patent because the first person has filed earlier. So that is why this provisional and complete specification is there. In between, you get a time period of 1 year for submitting your complete work. After you have submitted your complete work, your your invention will be published, and it will take around 18 months. After 18 months, our office will publish your invention in the Gazette of India. Okay. So this 18 month is there. I'll let you know why this gap of 18 months. So after the publication, that is after you have submitted the complete application and after it has been published. So, and you have filed Form 18 that I said earlier, that is the request of examination. After that only your application will be considered for examination. And examination is like we will be going through the technical examination as well as formal examination. When I say formal examination, it means your forms will be checked whether you have filled in the correct details, are the like correct or not, authentic or not. Then in the technical examination part, we will check your invention technically. Okay. In that, we will be checking throughout the world whether the invention that you have mentioned, is it authentic, is it correct, is it the first time that somebody has come up with that invention or not. And if like it has already been published somewhere, it has already been granted somewhere, then your patent will be refused. And if not, it will be granted. Now there will be some objections from our office, obviously, which will be given to the inventor, that is called first examination report. Like I said, when your examination is examined by our office, we will be putting out a report which is called first examination report, in which there will be certain objections. Okay, then the applicant or the inventor has to reply to that first examination report within 6 months, and it can be extended to 3 months. Okay, with some reasons that why it has been extended. So you have to reply to that report, and after reply, we'll again consider your application. We'll see whether the objections that we have raised earlier has been met or not. If it is not met, then again we'll give you a report which is called second examination report. Then you again reply to that report in 6 months. And after this process, the final is the hearing. And in hearing, the invention will either be granted the patent or it will be refused, depending upon the objections have been met or not. Okay, so this is the procedure for ordinary filing. If you are an Indian person, you will file your application. It will be published in the Gazette of India. Then our office will, do technical examination over it. We'll send you a report that is called first examination report. You will reply to that report. And after this process, final hearing will be done and the case will be disposed, whether granted or refused. Right. So, like I mentioned, that there is a time of 18 months that you submit your application, and after 18 months, it is published. So, those 18 months are basically for screening purposes, because sometimes what happens is application may be related to defense purpose, some pistol or anything related to defense, or sometimes it is related to atomic energy. So, in that case, we need to have a clearance from the Department of Atomic Energy or from the DRDO, as the case may be. And after clearance only, your application is published. Okay. And then it is allotted to examiner for examination. This I have already told you, like this is the examination, the formal examination, the technical examination. The formal, like I said, the formally your forms will be checked, and technically in technical examination, your invention will be checked thoroughly. Then the first examination, then you reply to that, then comes the hearing, and final either the refusal or the grant. So this is how the patents are basically filed and granted. Okay. While granting a patent, we always check for the novelty and the inventive step with respect to that very invention. Okay. So what is the inventive step? What new is there? It is not like you can copy paste something which is already there. So we always go for the inventive step and novelty. That is what is checked under technical examination. Right. So this is timeline. Like I said earlier, if you are not done with your work, you can submit a provisional application, but within a time of 1 year, that is 12 months, you have to submit your complete application, right? then you have to file Form 18, like I mentioned earlier. That is the request for examination. After filing Form 18, within a time of 48 months from the first date, after that only your examination, the examination of your file will be done. Then when we submit, when we give a report to you, that is called first examination report, you have to reply to that report within 6 months, and so on. These are several other timelines. Okay, so the major timelines are like 12 months, 48, 6 months. Okay, so now moving to designs. Like now, up till now, I have told you what are the patents, how they are filed. Now designs. Design.
Anshul, 1 minute. Can I continue from here?
Yes, sir, sure. Why not?
Okay.
Always.
Hello, everyone. Am I audible? Hello, am I audible?
Yes, sir.
Okay.
I need to stop sharing screen first. Yeah, please.
Is this slide visible to you, everyone?
Yes, sir.
Is this slides moving? Slides moving or not?
No, sir.
Hello?
Slides are not moving.
Slides are not moving. Okay.
Pratik sir, go to the slide show first.
Yes, sir. Yes, sir. It is moving now. Just do the slideshow.
From current. Yeah.
Is this changing?
No, sir.
On the bottom right, there's this option for slide show, then it will change.
Now? Is this changing or
Not changing.
okay? Is this visible?
Yes, sir.
Yeah. Now changing, right?
Yes.
Yeah.
Yes.
Good afternoon, everyone. Anshul sir have given you brief idea about patents. So I will continue from next IP, that is the design. So design is any ornamental or composition, patterns, lines on any object, which can solely judge by your eyes. If you are able to differentiate two different objects which having different shapes, colors, patterns, two-dimensional, three-dimensional patterns. So that comes under design pattern. And for design, that doesn't require any constructional feature or any composition parameter. The final object is the only thing is going to judge in design pattern. So in this exam, in this picture, it's showing that this car having a leafy flower structure on this car. That's also example of a design. And the term for design patent is 10 years. Initially, you are getting rights for 10 years and then it can be renewed for next 5 years. So total term is 15 years. In design, it can be anything. Your wristwatch, cycle, the design on your mask, design of toys, design of your pen, design of your phone, everyone having their unique phone. So each phone having their unique shape. Also design of your laptop, mobile, tablet, set of sofa set. In the market, there are many mineral water companies, bottles, mineral water bottles companies are there. But each company having their unique design structure. And no other company is copying same design as them. Example is a Coca-Cola bottle. Suppose the shape of Coca-Cola bottle is then patented under design patent. So the Coca-Cola bottle having the unique shape, and no other competitor company also can copy that shape. So that's why it's with Coca-Cola only. Another example, in market, you are seeing many companies selling their products on Tetra Packs nowadays. So each company having their unique shape of Tetra Packs. You can assume or try to remember that in market there are many products which are coming in different shape of Tetra Packs. Now this design patent not only given for a single article. If you have a special design on single article, then also you can file for design patent. But if a set of products are there, like a crockery set, jewelry set, then also sofa set, for that set of items also can file or get rights under design patents. As I mentioned this example, that crockery set, jewelry set means more than one item. So it can be a different design. In filing procedure for the design patent, in India there are 4 offices as mentioned for patents. Delhi Patent Office, Mumbai Patent Office, Chennai Patent Office, and Kolkata Patent Office for patent. But for processing of design patents is taking place only at Kolkata. You can file your application at these all 4 offices, but these offices are the only receiving offices. These offices accepting your application and then sending to Kolkata offices, because at Kolkata only the special design team is present. So they are examining your process and giving further decision. The fee structure for design patents is, for application is 1,000 rupees for individual, small entity, startup, and if you are filing as a other than natural person or as any company, for them the fee structure is 4,000 rupees. There are some forms same as patents for design. The forms for form 1 is for application form, in which the details, that is application, applicant's full name, nationality, address, in which class he is applying for that article. Then priority date, registration date, that's it. Such you require to submit 2 sets of your design to office, and then further examination process will start at patent design office, Kolkata. This is also example of specimen where the final design is only this is a tea or coffee maker machine, in which teapot. So the design, they are giving rights for design, not for constructional feature or the composition of the making of that design. This design rights is given for that the final design. This is the final certificate, how it looks like after getting the design patents. Now, how can you show that this IP right, the design patent is protected? How you are showing to on your product? You can show as a registered that product number after a successful registration or approval from design office. You will get registration number. So that time you can show that registration number, or only registered or REGD or RD. These symbolize that product is under a registered design. Design, it can be anything like your chair from your home. The Nilkamal chair, that also comes under design patent. So the timelines for this design patent, as I have mentioned, the term is 15 years. Next IP is trademark. So trademark is a sign or symbol, logo, which are capable to distinguish of one services of one enterprises to another one. So can anyone tell me this symbol belongs to which brand? This symbol belongs to
Amazon.
First one.
Amazon.
This
Amazon.
one? No, Amazon, no.
Puma.
Yeah, right. Puma. This is belongs to Nike.
Nike, Nike.
This belongs to
McDonald.
Yeah, right. So by just by seeing that logo, you are able to identify that brand. So this is the power of that trademarks. So trademarks, which subject matter comes under trademarks? The brand name, tagline, certification marks, sound marks, logo, smell, scent, or moving marks. That all comes under trademark. If you are sitting at your college and if you listen a special ringtone of iPhone, just by listening that ringtone, you are identifying, this phone belongs to iPhone only, or Apple phone is there. Similarly, just by listening this ting, ting, ding, so you can recognize this tone belongs to Britannia. So this is also comes under trademark. Now, in previous slide, you identified the different signs and symbols. But here, the tagline also mentioned. So taglines also makes a big difference. That is Nike, just do it. Then Coca-Cola, open happiness. So that open happiness also a tagline for that product. So that's also comes under trademark. The certification marks like BIS mark, ISO mark, that's a part of certification mark. Then the combination of colors, if you are finding any logo and which having different colors, that's also comes under trademark. Moving marks, so which are comes under a trademark. So the good trademark should be distinctively different from the present one. It should not be deceptively similar, because if you are making your product as a trademark, so that time you should be aware that no one can copy similar subject matter. Some examples are like Adidas as a some cheap company, cheap quality products are making Adidas as a Abibos, then Puma as a Puma, Nike as a Nike. So this cheap quality products company getting the benefits from the name on the name of big trademarks. Also, example, Parle-G become Parel-G, Regal-G. So if you are filing for trademark, then you should think that your idea or trademark should not be deceptively similar to the previously or not already existing marks. Now, how can you identify that this product is registered trademark or not? If R in circle, that means that product is a registered trademark, and just only TM mentioned on any product. So that means that product is filed for the registration of a trademark. Next, IP is copyrights. How can you find out that this product are copyrighted? So C in circle, that means that product is copyrighted. Copyright is a legal right given to a creator for his expression of idea. Expression of idea can be literary work, artistic work, musical work, dramatic work, cinematographic work. So these all comes under copyrights. Copyright is a bundle of rights. Bundle of rights means it gives you moral rights and legal rights also. Then it is automatic right. What is the meaning of automatic rights? अगर आप में से किसी को कोई अच्छा नया पोएम आता है, माइंड में आता है, चलो ये पोएम मुझे अभी आ रहा है, the time when you note down that, from that time, automatically that rights belongs to you only. That it is exclusive right given to a creator for his expression of idea or his authorship. So copyright cannot protect an idea. Means agar I'm good in playing guitar, and if I in my brain I find out that this tone will be a good one, but I haven't expressed that. And similar tone made by one of my friends. So I can't claim for that tone's rights because I haven't expressed my idea. That idea was in my mind only or in my brain only. I haven't expressed. So copyright is given for his expression of idea, not for the only concept or idea in your mind. Copyright is an exclusive legal rights given to creator for his expression of an idea. You're required to express your ideas, then only you will get these rights. Copyright owner has rights to reproduce, translate, adapt, perform, distribute. Also, one more thing, registration of copyright is not mandatory, but it is more recommended because if anyone stolen or copied your artistic work, like if anyone copied your poem or any news article or any storybook, so that time if you have registered copyright for that artistic work, so you can easily prove that these are registered one and I have the priority of this or rights with me for that arts. So for legal enforceability, it is more recommended that to get registered under copyright. Copyright is given for this 6 to 8 sections. That is literary work, paintings, drawings, photographs, films, music, choreography, and sculpture. In literary works, it can be a news article, newspaper, blog, books, novels, story, poem. These all comes under literary work. Then paintings, drawings. If anyone is good in paintings or drawing, so he can file for copyright under this act. अगर आप में से कोई very good in photography and he have captured very scenic photos of your local area, so and he filed for copyright of that photo, so no one can copy that photo without his permission. If anyone wants to use that photo, the photographer can get the benefits, monetary benefits in the exchange of that photos. So this is also a good option if you are getting taking the copyrights for your artistic works. Similarly, films, music, and sculptures also comes under copyright. Now, what are the terms or validity of this copyright? For literary and dramatic work, the term is for literary work, the term for copyright is lifetime of author plus 60 years after the death of author. That rights goes to their legal hire. Suppose I am the author of one book. The rights is with me till my death. After my death, my legal hire will get enjoy that rights for more 60 years. So these are the terms. Then if you are making any sound recording or any film, the rights is with for 60 years from the date of publishing. Means जिस दिन से वो publish हो रहा है, from that date 60 years will start. Another example, another rights is broadcasters rights. Example, Kapil Sharma show's rights is with Sony TV. So no one can copy or telecast that show without Sony TV's permission. And Sony TV can telecast that show as per their wish, as per their choice, any number of times. This broadcaster's rights is for 25 years. Another example is Antakshari. The broadcasting right for Antakshari show is with ZTV. So ZTV can show that or telecast that show as per their wish without anyone's consent. But no other competitor or any channel can telecast Antakshari show without ZTV's permission. So this comes under broadcasters' rights. Performers' rights. Performers like singer, actor, musician, dancer, juggler, circus act. These they having rights for 50 years. Next is geographical indication. Geographical indication is rights or tag given to products which having special qualities due to local environmental condition and local labor skill. So Geographical indication is sign used or on products which having special qualities or originating from particular geographical origin and which having a special qualities or reputation due to that origin. Example, Mahabaleshwar strawberry or Puneri pagdi, Nagpur oranges, Kolhapuri chappal, Kolhapuri jaggery, Nasik grapes, Jalgaon banana, Darjeeling tea, Makrana marble. The marble which used for the making of the Taj Mahal is from the place from Rajasthan. That is the place name is Makrana. So the name is given as a Makrana marble. So by this example, you can find out that this name given that local region name is given. Another example is Ratlami Sev, Kokan Hapus, Nasik grapes. So the name given to that product based on that local origin place. As you are from Junnar Taluka, so currently some association have filed for the Junnar Hapus or Shuneri Hapus on the name of Junnar Hapus or Shuneri Hapus to get this tag, that is geographical indication. It's the process on it's not yet given, but its process is going. So if that get the tag, then you can get the benefits also for that. So next IP is trade secrets. Trade secrets means you are not disclosing any particular your process or composition or recipe of your product to anyone except your core team. Example, Coca-Cola. The taste recipe of Coca-Cola they have kept as a trade secret. So no one can copy or can able to make similar taste as Coca-Cola till today. Another example is Big Mac sauce from McDonald's, KFC, Nugget. So these they have protected or kept taking rights as a under trade secrets. Now, as you are from technical background, you are using Google as your searching platform. But why you are using Google? Because it is a fast, also give more number of result and accurate result as compared to the other available searching platform. The algorithm on which it is based of so they kept that algorithm as under trade secrets. So due to that, they are getting monopoly and earning more money. So this is also a good type of IP. So what are the validities for these IP rights? For patents, it is 20 years and there is no concept like global or international patent. If you want to enjoy or make a business in particular 4, 8, 10 countries like India, Japan, Australia, USA, Europe, then you require to file in that each particular country for patents rights. Next IP is design. For design, validity or term, how much time you will enjoy that rights is 15 years. For trademarks and geographical indication, initially you are getting rights for 10 years and after 10 years you can renew for further 5 years for this IP rights. Next IP is copyrights. For copyrights, as I have mentioned clearly in previous copyright slide, that the validity or term for copyright is lifetime of author plus 60 years after the death of author. Now, who can apply for this IP rights? Any person or any legal representative can file for this IP rights except for geographical indication. For geographical indication, it can be filed only by firm, partnership, small entity, body, corporate body, or a group of villages comes together and they can file for geographical indication tag. These all IP rights are territorial in nature. Means if you are getting patents to you in India, the boundary where you are enjoying the rights is only India's boundary. India's outside India, you can't enjoy that right. If you want to make a business outside India, then you require to file in that countries also. So these are some of the examples. In Mona Lisa paintings comes under copyright. This sculpture comes under design and copyright. These Apple products having multiple IPs in it. That is a trademark for their logo. The design of MacBook or phone, it comes under design patent. Then LED display or the fingertip sensor or camera, that comes under patent. And the manual of all these, each product comes protected under copyright. This Coca-Cola bottle, this also having 3 different IPs in it. That is, the shape of bottle comes under design patent. The name Coca-Cola, that comes under trademark, and the recipe of Coca-Cola is a trade secret. So in a single product, they're having multiple IPs. And the Bisleri is the name. It is for trademark. So in this is related to all IPs. We covered patents, trademarks, design, copyright, geographical indication, and trade secrets. So as you are from technical background, so I will give just a small summary points related to patents. Patents is given to invention which having 3 qualities or 3 criteria. That is a novelty, inventive step, and industrial applicability. Means novelty means it should be a new, not knowing to anyone. Inventive step means that having added advantage over previously available things. And industrial applicable means if you are making any invention which should useful to all the people, all the industry, that comes under industrial patent. Because if anyone made an atom bomb, that is not useful for all the people. So your product should be such a way that it will be useful for all the industry. Now there are some criteria that which are not patentable, like method of treatments, then computer programming. As in India, for computer programming, India is not giving patents. But for program, if you are having invention is embedded with software embedded with hardware, for such cases patent can be given. But if you are fulfilling this criteria, that is novelty, inventive step, and industrial applicability. So I think you all are basically clear about what is invention and discovery. Invention is solution to a particular problem that comes as an invention. It can be a small thing, big thing, a small needle, small paper clip, to robotic machine, CT scan machine, MRI machine, and so on. So it comes under invention. And discovery is just finding out the previously unknown thing, the already existing thing, that is a discovery. So patents is given to the invention. I think this is the basic you require to know. Thank you everyone. Thank you college. Thank you all the staff, faculty. Thank you Anshul sir. Thank you my family, Rida and Pranali, for their support. Thank you everyone. If anyone having any doubts, you can ask.
Hello. Hello.
Yes.
So what we'll do if design patent is copied by someone and just changes in same design? So what we have to do?
If you have a registered design patent with you and someone copied, so there are legal remedies available. So you can go and take the legal action against them. There is a legal remedies available for all IP rights.
How to issue when we do the patent? What are the issues are come?
Issues in the sense? Can you elaborate your question?
If I want to design some pattern if I design some new router techniques,
Okay.
wireless communication. So how we getting pattern if they are asking some IEEE that like the 802.11, that is a standards are there.
Okay.
So how the patent issues are happen? What type of issues are?
As I have mentioned in at the summary, that for patent, if your invention is fulfilling this criteria, that is novelty, industrial inventive step, and industrial applicability. So if you are making a router, then means it is applicable to all industry. So it fulfilling that industrial applicability criteria. But novelty and inventive steps. So for that cases, examiner will understand your invention, read your invention, then understand that, and based on your drawings and description, then he will try to search similar citation in all worldwide databases. If similar citation is available, then he will make report accordingly. So, as per your question, that what will be the issues, you require to check before finding that similar subject matter is not available, or you require to claim such a thing that new or novel only. Means, example, if you are applying for you are filing patent for bike, and your invention is in only in key holder. The key will start only when if you wear the helmet or the all the other you have license, or you are not using mobile. So it is in only key only, but you are claiming that I have the bike which having two wheels, the handle, the seat. So patent wheel is already known, handle is already known, seat is already known. So you require to claim such a way that in which point your actual invention is there.
So one more question is, sir.
Yeah.
If I so what is the easy step to get the patent? If you are some electronic students having designing some new power supply or some hardware they design. So what is the easy step?
Actually, easy step means if they have invented a new thing which are not copied from anywhere, so they can file for complete patent. But make sure the claim should be clear and concise. That invention is related to that. What is the difference that currently available power supply or transformer and the new your invention? You require to explain that things. अगर कोई फ्रीज बना रहा है तो ऑलरेडी फ्रीज नॉन है, लेकिन जो फ्रीज में डिफरेंशिएशन है कि फ्रीज में कूलिंग होने के बाद ही उस पर टीवी चलेगा या उससे पंखा चलेगा, ऐसा कुछ जो एडेड एडवांटेज दे रहे, तो आपको क्लेम वो एडेड पार्ट पे करना है। फ्रीज तो ऑलरेडी नॉन है, कूलिंग होता है, फ्रीज में सब्जियां रख सकते हैं, ऑल थिंग्स है, लेकिन आपका इन्वेंशन कौन से पार्ट, जैसे आपने बोला पावर सप्लाई ऑलरेडी नॉन है, आपका पावर सप्लाई में क्या आपने ऐड किया, कि आपने गोल्ड यूज किया है, प्लेटिनम किया है, या मेटल से चल रहा है, जो कुछ है उससे एनर्जी कंजम्पशन 100 टाइम्स बढ़ रहा है, कम हो रहा है, जो बेनिफिट्स वाला है, आपको यूजेस नहीं लिखना है, जो टेक्निकल एडवांटेज क्या है या टेक्निकल पॉइंट्स क्या है वही क्लेम करना है। नॉर्मली क्या होता है कि ड्यू टू लैक ऑफ अवेयरनेस पीपल आर ड्राफ्टिंग अ क्लेम दैट after using this power supply your electricity bill will reduce by 200 rupees, 500 rupees, and so on. So you require to draft such a way that you just require to mention the technical points only.
Okay.
These are the, because already power supply is there, this is not a new technology. So you require to mention that key features only which are new than previously available. अगर कोई बोल रहा है कि मैं मोबाइल बना रहा हूँ, तो मोबाइल ऑलरेडी नॉन है, देन कीपैड वाला है या टच स्क्रीन वाला है, तो पहले कैपेसिटिव आता था, रेजिस्टिव आता था, तो वो भी अवेलेबल है, तो तुम्हें न्यू तुम्हारा क्या है, पहले फिंगर टिप सेंसर न्यू था, अभी फिंगर टिप भी हो गया, रेटिना भी हो गया, तो जो एडेड है वो फीचर को मिलेगा, पूरे मोबाइल फोन को आपको पेटेंट नहीं मिलेगा। आपका जो स्पेसिफिक फीचर है कि हाँ रेटिना स्कैन करके फिर बाद में हाँ भाई मेरा कुछ ब्लड का खून लेके वो ओपन होगा, जो भी कुछ एग्जांपल है। तो ऐसे में आपका जो एडेड वाला न्यू वाला इन्वेंशन है, इन्वेंटिव पार्ट जो है, उसी चीज को आपको क्लेम करना है। डिस्क्रिप्शन में आपको पूरा एक्सप्लेन करना है कि ये इन्वेंशन है, ये प्रीवियसली ऐसा आइडिया था, मेरे में ये चेंजेस है। आप वो एक्सप्लेन कर सकते हो, आपको जितना डिस्क्लोजर देना है वो। लेकिन क्लेम्स वाला जो पार्ट है, आपको पेटेंट्स पूरे आपके डिस्क्रिप्शन को नहीं मिलता, जो पूरा जो आपका जो सिर्फ मेन क्लेम्स है,
उनके
क्लेम्स
लिए।
में आप क्या क्लेम कर रहे हो, जो एडेड टेक्निकल फीचर से उसी को पेटेंट मिलता है। तो यू रिक्वायर्ड टू ड्राफ्ट सच अ वे दैट the examiner should not be confused by reading that. Just give clear that in description you should mention all the details. In claims you require to give the specific or key features only, that this invention is this and this will work like that.
One more question, sir. If someone publish the research work publication,
Okay,
then we can patent for that, go for the patent for that.
you have already published your research work as any paper, research paper, and
Okay.
then you want to file for patent, like
Yes, sir.
there is a timeline of I think 6 months. If your own invention or paper is published and you are filing for patent, then you can file for patent within 6 months after publication. But it is more recommended that first you file for patent and then go for any publication, means any newspaper article also. अपने यहाँ क्या होता है कि just for pride or any other things, they are people are showing that I have invented this on newspaper, they are going to publish before filing patent or any research paper. So it is a more beneficial if you avoid such a publicity before filing filing for any IP rights.
Okay.
After filing, you can go for any publicity or whatever you want to do, because that goes for public domain. As a site, examiner can cite that article, that by reading that news only, the other person can understand similar invention. So that's also can be a citation for your case only.
Okay. One more question is there. I go for the patent. Their online form filling is there.
Yeah.
After that, some money we have to pay for the patent fees.
Yeah.
The duration is more when we go for the patent. What happened at that time? What they decide for the how to if we go for the first we fill the form for the particular point, then we have to pay the fees for the patent. They require the more time for the giving that process. Why this happen?
More time given means actual examination will start late, right? You want to say?
Yes, sir.
Actually, as per standard timeline, it is a government policies. They have given some standard timeline that initially you are filing for patent. Then, as in slides, Anshul sir also mentioned that if you are filing in India, then it goes for screening and classification purpose.
Yes, sir.
At that time, they are screening that this subject matter belongs to DRDO or atomic energy. If that belongs to, then send to them by their clarification. If they approve that this not belongs to DRDO or atomic energy, then it goes for normal. If subject matter is not related to DRDO or defense or atomic energy, then it directly goes for queue for publication. But standard timeline is 18 months. Only after 18 months it goes for publication. If you want to publish your application before 18 months, there is a new form they have given. That is a form 9. Just by filing form 9, you can publish your application. Only publication. Publication of your application will be taken place within 1 or 2 months only.
Okay.
Publication means grant or decision. That is a different thing. Publication means this XYZ Raj has applied for this ABC patent, and this is title and description. That's it. That means they are publishing in Gazette publication of Patent Office only.
Okay.
So that comes under publication. After publication, it sends to same subject matter examiner. Means if your invention is related to electronics, then it sends to electronics background examiner or mechanical, civil. So based on subject matter, it sent to that examiner. So then as per number of queues, because in India there are filing is I think almost each year 40-50,000 new patents are filing. So each examiner having their quotas. So based on your number or queue only, it goes for further examination.
Okay, thank you, sir.
Okay. Any more question?
Okay, good afternoon, everyone. I, Professor Rohile Suvarna, on behalf of Samartha Group of Institution, College of Engineering, Belle, would like to thank Mr. Pratik Hendre, sir, and Anshul Sharma, sir, for their valuable time. It was really informative session. I also want to express my heartfelt gratitude to our principal, HOD, and staff for providing the support to make the webinar successful. Thank you all participants for their active participation in webinar. Feedback link is provided to you in chat box. Fill it. The certificate will be given to those only who had filled the feedback form. Thank you, everyone.
Thank you.
Thank you.
Thank you, sir.
Thank you.
Thank you, sir.